Earlier you said that the Supreme Court also handles criminal cases and has criminal jury trials?
Yes, that's right. Serious criminal matters such as contempt of court, murder, manslaughter, aggravated assault, robbery, and major drug cases are heard by Supreme Court judges.
So in criminal cases, you always see case names like Regina versus Smith. Who is Regina?
Well, Regina is the Latin name for queen, and as the queen is the head of state in Canada, the government lays the charge using her name. A crime is considered to be an offense against the state.
Does the government have its own lawyers?
Yes, the government hires lawyers to act on behalf of the community and society. These lawyers are called Crown Counsel or prosecutors.
Are there criminal jury trials in Supreme Court?
Yes, the jury in a criminal case has 12 jurors who must make a unanimous decision.
Okay. And so the person charged gets to decide to have a jury trial?
Yes, it's called an election. It usually is made in cases where the accused could be sentenced to more than 5 years if convicted. For these more serious offenses, preliminary inquiries would have been held in provincial court before the trial is heard in the Supreme Court.
Okay. Is the preliminary inquiry like a trial?
Well, not exactly. A preliminary inquiry is a proceeding where the Crown has to present enough evidence to the court so that the judge will commit the accused for trial in the Supreme Court. However, the accused does not have to present a case at this time. Generally, at a preliminary inquiry, the defense counsel cross-examines the Crown's witnesses. If the defense counsel thinks that the Crown has not presented enough evidence to commit, he or she can ask the judge to dismiss the case at this point.
Okay. So an accused can elect to have a judge and jury trial. Are there any offenses where the trial must be by judge and jury?
Yes, for murder, skyjacking, and several other serious offenses, the trial in Supreme Court is by judge and jury, unless both the accused and the Crown Counsel agree to trial by judge alone.
What about in a murder case? Can the accused settle if he or she doesn't want to continue with the trial?
Actually, an accused can plead guilty and have a sentencing hearing rather than a trial. But once a person is charged with a crime, only Crown Counsel has the power to drop or stay the proceedings. The accused cannot decide to settle, as in civil disputes, and witnesses can't change their mind about testifying.
Okay, so suppose two men get in an argument. If one killed the other and was charged with murder, do you mean the friend of the accused who witnessed the murder would be forced to testify?
That's right. Witnesses to a crime are compelled to come to court to testify even if they don't want to.
It doesn't matter that the witness might also be friends with the accused and that they might not want to put their friend in jail?
Well, it might be an unfortunate turn of events in terms of their friendship, but they'd be obligated to testify no matter how they felt about it.